Good morning, it's Alex Woods here, civil litigator, specialist in financial mis-selling and insolvency. Now, it's on this beautiful, bright and blue-skied Monday morning, 24th of February 2014. I want to talk to you about bringing your own claim. I have been increasingly forming the view that it's really almost natural and necessary in certain complex payment protection insurance claims, and if you've been watching any of the videos you'll know that I specialise in complex payment protection insurance as well as other financial mis-selling claims. I've become increasingly of the view that it's helpful for a consumer to actually issue the claim himself and not actually use a lawyer unless they need it down the track or at various key stages of proceedings. And I'm going to just give you an illustration of why I think that's important by reference to one particular case. This is a case that I've been bringing against MBNA, Europe Bank Limited, owned by the Bank of America, big credit card company. Now, MBNA's approach to consumers who've got complex complaints, consumers who aren't happy with the first offer of a payment protection insurance refund that comes along. MBNA treat your case in a very kind of a passive aggressive way insofar as in getting any response from them, getting any disclosure from them is really like getting blood out of the proverbial stone. MBNA, and furthermore, and this is a case that I give as an illustration, as an extreme illustration, but of something that's prevalent and problematic across all lenders, whether credit cards or fixed-term loans. This is a problem also because the level of experience of adjudicators, people who assess payment protection insurance complaints, surprise, is not always of the highest standard, and therefore, in order to actually, I mean, it's a bizarre situation really, because it defeats the whole purpose of the Access to Justice Act, or well, the Wolf reforms, in terms of the way civil litigation is brought, which is you must try and settle pre-action with your opponents and not issue proceedings. Unfortunately, it kind of turns that principle on its head, because the way that the banks, the credit card companies pull up the drawbridge and pull down the portcullis and stonewall consumers where complex payment protection insurance claims is concerned, only leaves one option for your average consumer and or your lawyer representing your average consumer, and that is to issue proceedings. Thereby, you get the claim bounced across to a legal department. In the case of MBNA, they have their own in-house legal department, and you can actually get on a telephone to somebody and talk to a lawyer who has sufficient intelligence to be able to properly assess what is often quite a complex case. So, and it won't get bounced because these are big, I was about to say monolithic, that's not quite the right word, massive corporations that simply look at the world and look at consumers in a process type of way, in a morally neutral way often, and really they want you to dance to their tune. And the tune that they're playing is make a complaint, 8 weeks, if you don't like our outcome, you can always appeal to Financial Ombudsman Service. And a classic example of this is a case that I've got here. Actually, no, this is another case. But I've got three cases against MBNA at the moment. But the case that I refer to is a classic example of this. The client was made a derisory offer, in my view, originally. He complained, and then they made him an increased offer, but it's still, in our view, inadequate. So that's the tune that they ask you to dance to, and then if you don't like the decision, as I say, they invite you to appeal to the Financial Ombudsman Service, who often aren't the best. They are quite inexperienced. There are very few lawyers who will be assessing your claim, or even partly qualified lawyers. They're quite junior 21, 22, and they're quite a junior bunch. They will assess your claim. They often won't be able to get to grips with the complexity of your case, whether it's because there's a factual issue of one word against another, in reference to a case I have against Egg, in which the online application form says optional, and therefore the FOS adjudicator, inexperienced FOS adjudicator, has said optional, paperwork says optional. That means the client wasn't forced to buy the payment protection insurance, therefore it hasn't been missold. Period. Well, yes, but Mr. Adjudicator, could I just draw your attention to the fact that you didn't actually ask the clients for their testimony? The fact that they say the telephone call took place at the time the online application form was filled in, and during that telephone call they were pressured into taking the payment protection insurance. And furthermore, your sister body, the FCA, has done an investigation into Egg over a 3-year period in the boom times and fined them nearly £1 million for systemic telephone mis-selling. And still you'd prefer, and here's the extra ludicrous part of this illustration, of this story, furthermore, Egg have supplied you with simply their standard online application form that they would have used during the time. They haven't even supplied you with the original. Yet you, perhaps in a hurry or to get a large quantity of claims through, or perhaps on account of your inexperience, have made an assessment purely on the paperwork, when we know that so much of payment protection insurance was missold through pressure phone selling. Paperwork looks good, that's the whole point. Salesman makes sure the paperwork looks good, but he pressures you or he tells you you've got to take it. So that's just an illustration of a case that will fail the FOS process on the merits, but also FOS only bounce claims that they successfully adjudicate on behalf of the consumer, in favour of the consumer. They bounce the quantum calculation, the value of the claim, back to the bank or the credit card company to tell the consumer how much it is that they're entitled to. Now, there's a small minority, fortunately a courageous small minority of consumers who don't like that approach, and they're pissed off with the system treating every claim as the same, even where there's a significant complexity. And there is a significant minority, in my view, of complex payment protection insurance cases. So, but here's the thing, rather than use the lawyer, rather than go for your lawyer, issue the claim yourself. That way it gets bounced up to a person who actually will be able to properly assess your claim. Okay, I'm going to now just, before I'm going to go into a simple A to Z, well, ABC really, of how to bring your own claim, and you'll find some materials at the bottom of this posting and some links, etc., that'll assist. But I just want to say one thing before I do, to reassure people out there who may be thinking, well, hang on, Mr. Woods, solicitor, it's all very well you talking about issuing your own claim. You're a lawyer, you do this day in, day out, it's bread and butter to you. I'm just an average Joe consumer. Am I really going to try and embark upon an exercise of bringing a major bank or credit card company to court? Are you kidding me? So this is, but here's the thing. I myself, before I was a lawyer, brought a small claim, that's the operative word, through the county court and was successful. It was about £2,000. It was over 15 years ago now. And I won. He didn't turn up at court. Now, you can do the same thing. And because of the change of the law on the 1st of April 2013, two things have happened. Number one, it's more difficult for lawyers such as myself to bring claims on your behalf because the no-win, no-fee regime has been substantially dismantled. And the other thing is the limit for the small claims track has gone up from 5 to 10,000. There was talk of it going to 15. It may yet go to 15. This means that that'll catch a lot of the sorts of smaller claims that complex PPI claims. And you know, don't forget that if you do bring a claim for under £10,000 to the small claims track, it's not necessarily the case that the judge isn't handcuffed against giving you a higher award. So you fill in your claim form with your paperwork and you value the claim at approximately, because you won't know precisely, £10,000. You get it allocated to the small claims track, and then ultimately there may be more, but by then, you know, that won't be an issue. Now the thing that you need to understand is that there are a number of different ways of bringing claims to your local county court. There are a number of different tracks, and these tracks are multi-track for complex claims, and often for claims that don't involve simple amounts of money, such as proceedings to repossess someone's home. So PPI on second charge mortgages, where the bank is bringing repossession proceedings, you need to watch a different video bulletin on that. There's this fast track, which is for claims of a lesser value. Then there is the small claims track. Now that's quite different from the fast and the multi, because the principle of the small claims track is that you do not have to pay the legal bill of the other side if you lose. The idea is that lawyers are kept out of court, or as often as the case in the judge's office, his private office, his chambers. It's a very informal process. A lot of the litigation rules simply don't apply. There's far more flexibility, and your hand will be held to a not insignificant extent. But the biggest thing is, as I say, unlike the other tracks, you aren't exposed to a big legal bill of a bank that's decided to intimidate you by instructing expensive lawyers. That is, providing you haven't, you know, spuriously brought your claim and it's clear, you know, where there's clearly no merit. I mean, there are rules that say there's got to be at least some clear substance and merit in your claim. But now there are some. There is a danger of some costs implications that you might have to bear, experts, fees, other disbursements. But in the types of claims that I'm talking about, financial mis-selling claims, PPI claims, you're unlikely to have. There's unlikely to be an expert instructed by the other side, or substantial disbursements. And the principle is, since you're a small consumer and they're a big corporation, it will be in your local county court. So it's a very good tool. I wouldn't advocate litigating, you know, as a lifestyle decision. Clearly, you want to resolve the disputes that you come up against in the course of your business or personal financial affairs without the need to redress to court. But unfortunately, because of what I've described, where you do have a complex PPI claim and a client who's just not satisfied, he knows deep down that he's being shortchanged. There's not much you can do in order to get a proper audience with that bank in question, short of issuing proceedings. So I'm just going to show you. I'm just going to go through the A to C as I described it of the court, the form. This is the N1 claim form here, which you can get online. As I say, underneath me are the relevant links, and you fill it in. Now there is the court fees, by the way, because you will have to stump up some court fees at the beginning of the claim, are around £250, depending which you issue online or by post, for claims of between £3,000 and £10,000. The form is relatively straightforward. You have to fill in the defendant's address, your opponent, the bank, use their head office if you haven't got a specific address that you're able to find. You put down the approximate value of the claim and the court that you prefer. Everything else is pretty much self-explanatory, except the particulars of claim box, and that's where you have to particularize your claim. You have to tell the story, but in an accurate, neutral way. Now that's something I'm going to post a video bulletin on subsequently, because it's quite an important subject and there are intricacies, if you like, insofar as financial mis-selling claims are concerned, but there's an excellent head of claim. The law of the land has created an excellent head of claim in 2006 when the Consumer Credit Act created a head of claim called the Unfair Relationships Test. As I say, I'll go into that on a separate posting. So there it is. That's an actual example of a claim form that I'm sending out today in a case. Going forward, in many ways, I advise clients it's a two-stage process. You take your claim all the way to the allocation stage when, if it's under £10,000, it should be allocated to the small claims track, a standard money claim. Up till that stage, long before you get to trial, you've kind of bounced your claim to a legal department or professionals at the bank in question who can properly assess your claim. Great, and that's cost you between £200 and £250, and you're not exposed to any costs. Yeah, so that's of immense value. I will just note that there'll be a question of what if you discontinue your claim. That's a complex footnote really to this video bulletin, which I will address elsewhere. But the broad principle is you'll have been able to have bounced your claim up to a sufficiently senior level for someone to actually address your claim, and not just address it, for you to be able to get the wheels turning in terms of getting disclosure from the bank or credit cards. One of the big problems, one of the big complaints a lot of my clients have had, and why they've actually come to a lawyer in the first place, is simply because they've challenged the bank's calculations, or they've challenged the bank's adjudication on the merits and said, look, I want to see the telephone log. I want to see the record of this phone call that you say happened at the time that the credit card application was taken out, in which apparently I allegedly said, please give me payment protection insurance. I'm desperate for it. Please give it to me. Or can I have my bank statements going back more than 6 years, please? Not just the last 6 years, going back to the beginning of the credit agreement. Thank you very much. And there are lots of things that unfortunately the current Data Protection Act rules or the Consumer Credit Act rules, Section 77, 78, etc. They don't have enough teeth to get the sort of data that you'll often need in order to, for you to effectively assess whether or not, for example, the credit card company has paid you out enough money. So that's the first stage. Now the second stage is you then will just take a view and say, well, I still want to go to court. And if you do that, you then have to pay, in broad terms, approximately £600. These fees, if you're successful, you may be able to recoup. But in broad terms, £600 is the cost. And if you, let's say the other side, as often as not, your opponent will want to settle well before trial. If any further than 7 days before trial the settlement occurs, you can write to the court and say, we've settled, can I have my trial fee refunded? And they'll refund the large percentage of that £600. So again, it's a relatively low cost, relatively low risk option to pursue your claim to stage 2, if you like, all the way to trial. And you will have to be prepared to go all the way to trial, because somehow your opponent will have a sixth sense about your commitment to your claim and whether or not you really can cut the mustard and you're prepared to go into a courtroom, or in this case a judge's chambers, where you'll be sitting down and give your testimony. So there it is. That's a quick whistle-stop tour around the small claims track. Not court. It's the same court. It's the same judge. It's the same law. It's the relaxed procedure. But it is the same county court that a multi-track and a fast-track case will progress through. But the difference is the track is small claims. So I'm just checking my notes if there's anything that I've missed that I ought to bring to your attention. Yes, the final thing is to say, of course, that I quite like the idea of pioneering in the course of time a support service, a small claims track, financial mis-selling, perhaps general litigation support service online, so that you can, you can go to the go to courts and you can get redress by means of the small claims track. So at any stage, what I'm saying is that at any stage, if you felt that, oh, this is getting a bit complex, you could come to that website and there will be materials there that will help you. Alternatively, you may wish to, at any stage, ring a lawyer. And I mean, this is just embryonic at the moment, but I can envisage a situation where I have a junior lawyer able to deal with people's queries online by email or by phone. So there it is. That's an introduction to the means by which consumers in financial mis-selling cases, generally I'm talking about payment protection insurance, can get redress by means of the excellent small claims track in their local county court. Finally, if you look underneath me, I'll put some links. Money Serving Experts, quite good on outlining the process of the small claims track, and then you've got forms to do with court fees, and you've got the government website that also breaks down the small claims track. Okay, so that's Alex Woods, as I say, posting off on this beautiful blue-skied sunny day on Monday the 24th of February. I hope that's been of value. Goodbye for now.